If you owe IRS tax and are thinking about filing bankruptcy, there's 6 basic rules that you have to know first. And this video starts now. If you want to stop any problem with the IRS, we'll show you our best insider tips, how-to guides, and little-known secrets to get there fast. Before we jump in, go ahead and click that subscribe button so you never miss another video to protect yourself and your bank account from the IRS. Let's go. Hi, I'm Anton, and this is Real Talk with Tax Law Offices. Thank you for joining me on this video. Before we get started, please, I would love for you to hit the like button, and while you're at it, go ahead and subscribe. Don't forget to hit that bell so that you never miss another video of what you need. Okay, let's get started. Anyone that owes a significant amount of tax liability has to consider some of their options as the best resolution or the way to deal with that tax, whether it's paid or satisfied otherwise. I want to tell you, kind of on a very basic level, how to navigate the 6 rules of what you really need to be able to discharge those taxes in bankruptcy. Okay, so this really is not meant as tax advice so much as it is to give you a guideline to help you discuss your bankruptcy options, either with your CPA who's advising you with your tax liability, or possibly even a bankruptcy attorney. So I get these questions all the time, not usually from bankruptcy attorneys, but every now and then, definitely from a number of CPAs, because they're not expected to know this information, and certainly from lots of potential clients and even existing clients. All right, that very first question though, and it's usually more in the form of a statement, well, I didn't know that I could discharge my taxes in bankruptcy. And you know, every time I hear that question, I smile, because I have to ask, well, why did you believe it? Why did you believe you couldn't discharge? And they usually say, well, I was told that I could not. Rule number 1, only income taxes or taxes that relate to or are derived from income can be dischargeable in bankruptcy. That means that sales taxes are not eligible for discharge in bankruptcy. Payroll taxes are not eligible. Corporate taxes, if they are corporate income taxes, they are dischargeable. First rule, only income taxes are dischargeable. All right, now the rest of the rules get to be a little bit more technical, so I'm going to do my best to make them make sense without being overly technical. Because really, who wants to hear the analysis of a lot of tax and bankruptcy code anyway, right? Okay, so second rule, if IRS has filed, or even the state, whatever state you live in, has filed a tax lien, the discharge of taxes becomes more difficult if you are trying to keep assets that may be subject to the lien. Let me explain. So at tax law offices here, we have this expression that we say to clients all the time who are trying to navigate the tax and trying to find the best resolution. And a lot of times that resolution means that they want to pay as little as possible. Okay, that's fair. But what we always have to remind them is that you don't get rid of the bad stuff, all the bad stuff, and still keep all the good stuff. And so then what that means is that, let's say you have a home that is mortgaged, and well, let's just say the IRS filed a federal tax lien for some amount of tax liability, and you want to discharge that in bankruptcy. Of course you want to keep your home. You can't discharge the tax because really that lien kind of attaches to the asset, to that home, just like another mortgage. And the very same way that you can't keep the home but discharge the mortgage in bankruptcy, well, you keep the IRS mortgage on the home the same way. Like I said, at a high level, just so that you understand that somewhat technical rule. All right, third rule, also, again, a bit of a technical rule. So tax liability is going to be the result of a tax return that's filed. And sometimes you file your own tax returns, most people do. Some people don't always file their tax returns timely, and in many of those cases, the government will file a tax return for them. So that brings me to this third rule. Unless that tax liability is the result of a tax return that you actually filed, then the tax is not going to be eligible for discharge. For example, if IRS filed that tax return for you when you did not file it, well, unfortunately, you just can't discharge it in bankruptcy. Another note about that rule: for those that file a tax return after the IRS or your state government files a tax return for you or for them, well, even if that return is to amend what the government did, and even if it's a lesser amount of tax, well, unfortunately, it's still not dischargeable in bankruptcy. So those first three rules were more general rules that discuss the qualification of that tax being dischargeable in bankruptcy. The other three rules are more timing rules. Let's jot these down because you want to be sure that you can discuss them either with your bankruptcy attorney or possibly your client, if you are a bankruptcy attorney or a CPA. To discharge any income tax in bankruptcy, the filing date of that bankruptcy has to be at least 3 years following the due date of that tax return. And that due date can include extensions. So for example, the 2018 tax return was due to be filed April 15th, 2019. And if that person filed an extension, then the due date would have been October 15th, 2019. Clear enough? All right. Next rule. So we call that one the due date timing rule. This one is slightly different. It'll sound kind of the same, but it's actually different. And this is the filing date timing rule. That bankruptcy petition, in order for that filing to discharge taxes in bankruptcy, that filing date for the bankruptcy has to come at least 2 years following the actual filing of that tax return. For example, that 2018 in our last example was filed April 15th, 2019. Well, then great. We know that 2 years after that is April 15th, 2020, 21. Okay, fine. And then we know based on the due date rule that you still couldn't even file that bankruptcy to discharge the tax for another year. And that covers the rule. So not to be overly complicated, that petition has to be filed at least 2 years after the actual return is filed. Okay. All right. This is our sixth rule. This is our third timing rule. This is not the due date rule, nor is it the filing date rule. And we just simply call this the assessment rule. Okay. To discharge tax in bankruptcy, that bankruptcy filing has to occur 240 days following the assessment of tax. So people usually ask, well, if I had to file my tax return 2 years before I filed, why wouldn't that tax already have been assessed? Well, and this is what happens, and this is why that rule exists. It has very little to do with when you filed your tax return. In the cases of a tax audit that comes long after you file a tax return, sometimes it's 2 or 3, or it's 1 or 2 years after you file a tax return. If there is tax liability increase determined in the audit, well, immediately after the audit, either the Internal Revenue Service or your state tax authority will then have to assess the tax. So it doesn't have anything to do with the due date of the return. It doesn't really have anything to do with when the return was filed. It has everything to do with the conclusion of that audit and additional tax being found from the audit and then later assessed against you. And the reason why that rule exists is because people were coming out of their tax audits, and as soon as there was a determination that they owed additional money, they went straight into bankruptcy court to try to discharge the liability. So in fairness to the government, what Congress did when they added this additional rule was to give the government a buffer of about 8 months to conclude the audit, assess the tax, and then to have some time to fairly attempt to collect the tax before the taxpayer could run into bankruptcy court to discharge it. All right, so that's why the rule is there, and that's the simple explanation of the rule. I want you to take these 6 general rules and just kind of keep in mind that if you're considering it or if you're advising someone about it, then these 6 rules kind of shape their opportunity as well as the timing of that opportunity if those taxes are actually eligible for discharge in bankruptcy. Now, if you run into a novel situation or have any sort of questions or comments, I'd love to hear what you think about these rules and how it may relate to some novel situation that you've seen or maybe even that you have. I'd love to hear about it. Please feel free to leave comments below, and don't forget to like the video and feel free to share, and don't forget to subscribe to our channel. Thanks again for watching. I'm Anton. This is Real Talk from Tax Law Offices. Thanks again. See you in the next video.